Let's talk about the purpose, policy, and procedure of Protocol 838, EMS Provider Criminal Charges and Convictions. Bonnie, when, why, and how was this protocol developed and implemented?
It was implemented on August 1st of this year. So just earlier this month, it went out, but it has been in protocol forever. But it's been buried in a PSRO protocol where most of our providers don't even go to in the protocol manual or the app. So we needed to make it its own protocol. So we did so, we created it, we developed it, we got it up to the state, got it approved, and it was implemented just a few weeks ago.
Yeah, John, when you came onto the OCMCA as the Quality Improvement Coordinator, one of the first things that was identified during our collaboration with the state of Michigan was that although this requirement has always been there, even our higher level decision makers, coordinators, we didn't even think about it. We were not aware that this requirement was black and white and in place. So would you agree that this protocol just kind of brings light and guidance for agencies to follow very simply?
Absolutely. It provides direction for the providers and making sure the provider understand that it's their relationship with their license with Dr. McGraw. And that's really where it's at. It's not the agency's relationship with Dr. McGraw. It's not the agency's relationship with the medical control. Dr. McGraw is the medical director. He oversees every EMS action that is done in Oakland County. He's the one that gives everybody the ability to work in Oakland County. And he has to know if there's been criminal charges or convictions. And this was buried deep in a protocol, very difficult to find. And we just brought it to the surface to make it easier.
Okay, so in this protocol, there's a few definitions right off the bat. There's charge and conviction. Can you guys please compare and contrast these two definitions?
So you walked into a store and you picked up a candy bar and stuck it in your pocket and you walked out of the store. A police officer ends up coming after the store detains you for a second and you get charged with shoplifting. You've been charged. You then go to court, you go to trial, and you're found guilty of shoplifting. You have now been convicted of shoplifting. That's the difference between charge and conviction.
Okay, so a charge is that formal accusation. It's the governmental authority that's asserting it, documenting it, and saying we have committed a criminal, misdemeanor, or felony. And it's really anything except for a civil infraction. Is that accurate?
That is accurate. So, and that can include operating while under the influence. OWI is definitely something that if you're charged with and or convicted of, you got to report.
Okay, so it's obviously two different things, and it's inclusive of a process. There's the charge that says you were caught or accused of doing something, and they have then applied legal parameters to you. You go through a process, and if found guilty, you are then convicted. And that's any plea of nolo contender, a guilty plea, or plea agreement, including deferments as well as convictions after trial. So this is the result of those charges, I think is the best way to describe that.
Yeah, that is 100% accurate.
Okay, so now that I know the difference, the rest of the protocol, I think, becomes much more clear to the lay person and provider. So there's the procedure section. So Bonnie, what does the process look like from beginning to end? I get charged, I get convicted. They don't always happen on the same day. So play it out for me.
Right. So it's really not the conviction, it's the charge. As soon as you have been charged, whether that results in an arrest or not, that charge is what makes it go into effect that you need to notify the Oakland County Medical Control Authority. It does say within 1 business day, but if you are arrested, don't make your one phone call us. Just let us know when you're out of jail. If you do get arrested, notify us in writing. We do need it in writing, and let us know what happened, and then we can go from there.
I think one of the best practices, maybe for our EMS coordinators or our managers of any type of EMS agencies, to be aware of this. So when they are reported to that it happened to one of their providers, they can assure that this protocol is followed. And that even protects the provider by making sure it was at least declared. If there's already a charge, they're already in a situation that isn't fun. By not following this protocol doesn't make it any more fun. So it does add to it by all of us being socially aware of it. Okay, so we notify at least 1 business day. There's a little bit of leeway depending if you're detained and cannot make contact that way. John, what's the next thing?
So the next step is the medical director, which is Dr. McGraw, is contacted, and he has to make a determine right then whether or not the provider has to be temporarily suspended. I know what everybody's thinking right now. Whoa, I've just been charged. I'm not even guilty. Well, if you're charged with murder, at that point in time, there's a reasonable expectation that the medical control has to take some steps and protect the patient.
So if I'm tracking, John, the medical director looks at the initial information of the case to determine if this person is an appropriate EMS provider for the system, and it's case by case. Sometimes the charge may be completely unrelated to their capacity as that EMS provider, although there are certain things in criminal acts that can occur that we don't want that person interacting with our citizens. So it's a case by case basis that gets filtered through the medical director to determine if privileges need to be suspended immediately. So let's say they do not or they do. Either way, the OCMCA then goes on to hold a more formal meeting. Tell me about that.
Then we do a Sentinel Event Meeting. And what that is, a meeting of the Professional Standards Review Organization and the provider that has been charged. And that provider will come in and explain what has happened. Now, we also have an understanding that your attorney might tell you not to. If your attorney tells you not to provide any information, please put that in a letter back to the PSRO. So the PSRO knows that you've at least acknowledged that there was a meeting, and then they'll have to make their decision based on the information that they have.
The Sentinel Event Meeting is a way for the PSRO committee to determine the depth of the situation and determine if further action needs to go forth. And as we said before, just like the medical director makes that initial decision, they review that again to assure, is this something we need to remove the person from going on EMS runs or not at that point? John, where can I find more information about Sentinel Event Meetings if I want to look it up? It is in a protocol.
It is in a protocol, and it is in the Complaint Investigation Resolution Protocol, and that is 8.27.1.
So you can look up more details there to identify what actually happens in those situations. But after that Sentinel Event Meeting, Bonnie, the final step is that the PSRO committee has to notify the state of the situation and the results. Walk me through that process.
So technically it's Dr. McGraw that does this, but we work through PSRO. Dr. McGraw is part of PSRO. And so really it's his name that goes on the documentation. And then we have to send that to the state. Whatever came out of that Sentinel Event Meeting, we need to let the state or Michigan Department of Health and Human Services know what happened with that particular licensed professional.
That seems pretty straightforward. It is as clear cut as it sounds. And a lot of this comes out of, quote, the law. And we hear a lot of people kind of use that as a crutch to say, well, it's in the law. What I like about this protocol is it provides a reference of that law. So where can I find specific information about this requirement?
Our law that we all operate under in EMS is the Michigan Public Act 368 of 1978. It's been amended twice. And we are really looking at parts 201 and 209. You can actually get it off of our website, OCMCA.org, as well as the Michigan Legislature website.
And I will be including a copy of a link to that as well for people to reference in the episode description.
Perfect.
Here's my final question on this protocol, Bonnie. Let's say I don't follow this protocol, meaning I don't notify the OCMCA, whether I know I need to or not, whether I'm aware of the existence of this protocol or not. What is the outcome of failing to assure I follow it?
That is really the biggest part of this and why we created a protocol, so our personnel do know about this. And the problem is it takes it out of our hands. If you don't disclose and notify us, we can't help you. And it'll go to the state, and the state will most likely, in most circumstances, take away your license or at least suspend it for a period of time until things are sorted out. So we really want everybody to report this so that we can take care of it locally and hopefully, take care of it so that we don't have to have anybody lose or have a suspended license.
By not following this protocol, you are violating another protocol. What that can lead to is a suspension of your privileges for a possible temporary basis, just for simply not following this protocol. And that was really what one of the big reasons we created this protocol or brought it to the forefront, was because we were informed that the state had been looking at people that have failed to follow this protocol, and they were getting temporarily suspended for a period of time. And we don't want that to happen. You've had enough problems. Now let's get to the mitigation part.
Yeah, and staffing shortages. I mean, they're bad enough.